with CIERRA.
Did you get a chance to look at this complaint? Because it came in pretty late. Yes? Okay.
Court will call 26 CF 199, State of Wisconsin versus Sierra McGarry. Appearances.
Cameron Davies for the state of Wisconsin.
Ms. McGarry's here in person with counsel Bill Ginsburg. We got a copy of the complaint. Waive its reading. That address is correct.
I have reviewed the criminal complaint. It alleges one felony charge. State's position on bail.
The state is going to be requesting $10,000 cash bail. I'll ask for the sole non-monetary condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. In terms of support for that cash bail, I'll note the defendant's lack of ties to Madison. The state is not aware of any ties. She has an Illinois address. I believe just by the very nature of the facts of this case was effectively traveling through the Madison area at the time of this incident. She also has a tremendous amount of exposure attached to this case with over 1,000 grams of cocaine in her possession. With those factors in mind, the state does believe substantial cash bail is required to assure her voluntary appearance.
Attorney Ginsburg.
The complaint does not have enough information that I believe the state would be aware of. Ms. McGarry was in an Uber vehicle. And if you remember how reading this, how there was this passenger or the driver of the vehicle and the driver's does this and that, the other thing, this is an Uber. She's not driving through Madison. She was in Madison, got an Uber ride. And as you can remember from the complaint, law enforcement apparently knew there was a drug deal going on, right? So they asked for assistance. It's in the complaint. They were asking for assistance because they knew they were going to stop this vehicle. It turns out, believe it was an Uber ride. So she was already here. It looks like this is just somebody who's in a ride with a backpack. I don't know that she's anything other than a mule, but the point is this. She has no prior record. She's 28 years old. She's full-time employee at Amazon. She has a 6-year-old child. She will, even with the it's still potentially a probation case for a first offender, especially if they had more information that she was arranging this deal, that she was on telephone calls, or she did this or that, the other thing, I think we would have that in the complaint. And so she will show up for court. She's retained counsel, which matters. As I said, she'll come back. Okay, I don't think she's going to just try to disappear. She'll be easy to find. She'll come back to court.
The quantity is significant. The exposure is significant. The lack of ties is important, but I've heard nothing that Ms. McGarry has any record, and based on your representation, she has none. Ties to the community are none. I believe some cash bail is necessary to assure her appearance at future court dates. I will set it in the amount of $3,000. I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. Time limits as to the preliminary hearing.
Waive time limits.
Time limits are waived. A status conference shall be scheduled. We're adjourned in Ms. McGarry's case.
Thank you so much.
Thank you.
Next up is Gary Stevens, appearing by Zoom. Looks like the video is turned on, but it looks a little bit frozen.
Can you hear us, bailiff?
He raised his head up to me, ignored me, turned it back down.
All right, looks like it's unfrozen now. Court will call 26 CF 189, State of Wisconsin versus Gary Stevens, appearances.
Cameron Davies for the state of Wisconsin.
Eric Suter appears, so I do have some information that I guess Mr. Stevens might want to represent himself at this hearing. I'm not entirely sure. I don't know if he's able to hear me, if we're able to, I guess, get in touch with Mr. Stevens.
I guess the bailiff said when we were speaking, he raised his head, put his head back down and has not approached the window. Bailiff, do you have any additional input in regards or update in regards to Mr. Stevens' whereabouts in the jail cell? See, the window is.
Mr. Stevens is still currently laying down, ignoring my efforts to get his attention.
We were just doing appearances, so
Okay,
go ahead.
thank you, Your Honor. Looks like Mr. Gary Stevens appears from the Dane County Jail along with counsel Skylar Boggio from the Public Defender's Office.
TORIBIO, I'm not sure what you heard. The deputy has been trying to get him to come up to the window. He raised his head, laid back down and is not participating.
Sure, and my understanding is that one of our secretarial staff members did or try to speak to Mr. Stevens, that he does not want public defender and he is asked to proceed pro se. Obviously, I will stand in as a friend of the court, but I won't be able to provide really any information at this point.
Thank you, counsel. The court accepts your friendship and it has reviewed the criminal complaint. It does allege one felony charge, state's position on bail.
The state is going to request $2,000 cash bail. I'll ask for standard non-monetary conditions. It's all likely somewhat moot. The defendant is facing revocation, so it's got a number of open cases. I believe he's got cash bail in a number of those cases, but this is his 6th open felony case for the same behavior. So the state really choice but to ask for more cash bail.
I don't have anything further from Mr. Stevens.
Given the conduct that's alleged, the number of open cases with Mr. Stevens, I do believe some cash bail is necessary to assure his appearance. I'm going to set it in the amount of $300. Time limits as to the preliminary hearing, Attorney Boggio.
I don't think I have the authority to waive them at this.
So it shall remain, it shall be scheduled timely.
Next up is Claudia Comer. Thanks, Comer.
I'm assuming that.
Court will call 26 CM 199, State of Wisconsin versus Claudia Comer, appearances.
Cameron Davies for the state of Wisconsin.
Ms. Claudia Comer appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Ms. Comer's complaint. I do waive its formal reading, reserve objections for a later court date. Ms. Comer informed me that the address on the complaint is currently correct. I would ask the court to enter not guilty pleas to the misdemeanor counts, and I'd also note that Ms. Comer is eligible for the services of the Public Defender's Office.
I have reviewed the criminal complaint. I do make a probable cause finding as to counts 1 and 2, state's position on bail. You're not guilty plea on her behalf.
The state will be requesting a signature bond. The state would ask for the sole non-monetary condition that the defendant make no acts or threats of violence towards the individual listed as child victim 1. For the sake of expediency, that individual has the initials KC.
Any objection, counsel?
No, Your Honor.
I will then give Ms. Comer a signature bond. I will order that you direct no acts or threats of violence to child victim 1 identified as KC. We are adjourned in Ms. Comer's case.
You don't have a no contact order. It's just it's no acts or threats of violence.
Next up is Stephanie Lindsay. Right this way, Ms. Comer.
Court will call 26 CF 193, State of Wisconsin versus Stephanie Lindsay. Appearances.
Cameron Davies for the state of Wisconsin.
So he's still get addressed.
And I'm very willing to do treatment under the JOSIAH.
Ms. Stephanie Lindsay appears in person and in custody alongside counsel Skylar Bojo from the Public Defender's Office. I have received a copy of Ms. Lindsay's complaint. I do waive its formal reading, reserve objections for a later court date. Ms. Lindsay informed me that the 1653 Wright Street address is correct. And I have indicated to me that she is eligible for the services of the Public Defender's Office. It does appear that she's already been appointed Attorney Eric Schluter on other matters and will likely have him going forward.
I have reviewed the criminal complaint. It alleges 2 felony charges. State's position on bail.
The state is going to request $500 cash bail. I will ask for non-monetary conditions that the defendant not possess or consume any alcohol. In terms of support for that cash bail request, I would note that the defendant is violating a specific condition of bond. She's doing so while committing a new crime, and not just a new crime, but the same crime that she is on bail for. Given the behavior in both cases and the violation of a specific condition of bail, some cash bail is appropriate.
Thank you, Your Honor. I also want to note I'm in receipt of a public safety assessment. It does appear that the recommendation from that is a signature bond, also with reporting and complying with pretrial services. From that report, it appears that she does not have prior felony convictions or prior violent convictions. She also does not appear to have any failures to appear on it. I think that some of the things that could be, or that pretrial services monitored, are things that can be monitored here, primarily like no use in random drug testing. Ms. Lindsay is, willing to comply with that, as well as, the jail Vivitrol program or any other type of, condition that would curb cravings and help with her AODA treatment. She does attend school at MATC. She also is employed at Taco Bell, but being a student and a worker at Taco Bell, she informs me she does not have the cash to post $500 at this time. She's been in Dane County for about 3 years, going to school and working, plans to stay here. I think with her complying with the, appearing at her court dates, and what the public safety assessment is recommending, I am going to ask that this court impose a signature bond. I do think that non-monetary conditions could be I'm not sure if pretrial services is currently taking applicants at this point, but I do think that she would be a good candidate for that, and I'd ask the court to consider non-monetary conditions in lieu of any cash bond. Thank you.
I do want help. I know I have.
PSA report does say that she has no prior felony convictions. She has no prior failures to appear within the last 2 years or older than 2 years. Given all of that and the charges in this case, I will give Miss Lindsay one additional opportunity. I will give her a signature bond. I will order that you not use or possess any alcohol during the pendency of this case. I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. Ms. Lindsay, I can tell you, if you pick up a new case, you'll be looking at cash bail because the number of cases and the potential penalty are too great. So you need to comply. You need to comply with these terms and conditions, or you will be getting cash bail. Time limits as to the preliminary hearing, counsel.
Okay, we'll waive time limits, Your Honor.
Time limits are waived. Status conference shall be scheduled. Ms. Lindsay's case is adjourned.
Thank you, Your Honor.
Next up is TORIBIO, MEDINA. Right this way.
Protocol 26 CM 200, State of Wisconsin versus TORIBIO MEDINA appearances.
Cameron Davies for the state of Wisconsin.
Okay, well, okay. And I can say first, Toribio, thank you. Toribio Medina appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Medina's complaint. I do waive his formal reading, reserve objections for a later court date. He's informed me that the address on the complaint is correct for when he's out, although he is currently on a probation hold. So I think now the Dane County jail address would be appropriate. And he's not eligible for the services of the Public Defender's Office. It does appear that Mr. Attorney Mark Leonard is representing him on his other pending case. However, the bailiff just provided him information to, I believe, get a county appointed attorney, being that he's currently not eligible. I'd also encourage him to reapply should any of his financial circumstances change. Lastly, I'd ask the court to enter not guilty pleas on his behalf for the 2 misdemeanor counts.
Attorney Boggio, it looks like that probation will be dropped.
Oh, it has, okay. Thank you.
I have reviewed the criminal complaint. Did you make a probable cause finding and entering not guilty plea on Mr. Medina's behalf? State's position on bail.
The state's going to request $500 cash bail. I will ask for non-monetary conditions that the defendant have no contact with Ricarda M.V. That's M as in Martin and V as in Victor. I will also ask for non-monetary conditions that the defendant not possess or consume any alcohol. In terms of support for that cash bail request, I'll note that the defendant, as noted earlier on the record, is on active supervision for flee and elude out of Greene County. He's also on bail for an OWI 3rd here in Dane County. So an alcohol-related offense, but an alcohol-related traffic offense. Here he now has an alcohol-related domestic offense where he was wildly intoxicated at almost a .24. So I think given that behavior on bail for an alcohol-related offense while under a period of supervision does make the state concerned about future appearance risk and the defendant's willingness to voluntarily abide by court orders.
Counsel.
Thank you, Your Honor. So first of all, I guess I did not realize that the probation hold had been dropped until just now. I think that's a pretty good indicator about, what the PO at least has trust in Mr. Medina for. He does have, it looks like, no failures to appear in the past 2 years. His other case that's open is a 25 CT case. So that means during the pendency of that case that there is not missed appearance. I do know that there are missed appearances that are older than 2 years. But at least on the current case that's open, it appears that he would have made all of his court appearances. What the state has brought up as far as the alcohol use, I think that's evidence of an alcohol disorder. I think it's evidence of an alcohol problem that needs to be addressed. Presumably a probation would, either be working with him on that now or will be. But I don't necessarily think that's an indicator of missed court appearances. heard other commissioners and prosecutors and quite frankly, as defense attorney, if, as far as drug use goes, I think fentanyl or heroin or opiate use sometimes can be an indicator of somebody who's going to be missing court, but I don't know if there's anything to support alcohol use in missing court. So he does have, I know he's not eligible for a public defender because of his current job. He informs me that he doesn't have the cash on hand to cover it at the cover the bond now. I am going to ask for a signature bond, and certainly I think, again, non-monetary conditions, pretrial services, those types of things could be a useful tool, although it might be a little bit redundant with the probation that he's on. However, I would ask the court to not impose a cash bond at this time.
There's a PSA report in this case. It gives Mr. Medina a 6 out of 6 on new criminal activity, 4 out of 6 on failures to appear. He's got prior pending charges at the time of the offense, 3 or more prior violent convictions, prior failure to appear is older than 2 years, prior sentences to incarceration. Given all of that, I do believe some cash bail is necessary to assure Mr. Medina's appearance at future court dates. That's consistent with the PSA recommendation. I would note there are Act 3 eligible offenses. Given all of that, I will set cash bail in the amount of $400. I will order no contact with Ricarda MV, and that you are not to use or possess any alcohol during the pendency of this action. Good luck to you, sir.
Thank you.
Next up is Maxwell Lampe.
Did I miss the trial branch on that? What's the trial branch on this one? Just filling out my sheet.
He's got an open case range too.
2, thank you.
Yes.
Court will call 26 CF 198, State of Wisconsin versus Max Lamp.
Today we're just doing bond conditions. Is that a good address? No. That's not us. That is that better. Okay. Okay.
Appearances.
Cameron Davies for the state of Wisconsin.
And Mr. Maxwell Lampe appears. Is it Lampe or Lampe? Lampe, I think. Mr. Maxwell Lampe appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Lampe's complaint. I do waive its formal reading and I reserve objections for a later court date. Mr. Lampe informed me that the address on the complaint is no longer correct. A correct address would be 9541 City Highway S, Mount Horeb, Wisconsin, 53572. And I have indicated to me that he is not eligible for the services of the Public Defender's Office. I see a bailiff giving him the form. I would encourage him to reapply should his financial circumstances change. And I would ask the court to enter a not guilty plea to 3 misdemeanors in the complaint. Looks like all except count 3.
I have reviewed the criminal complaint, and in looking at counts 1 and 3, they both appear to charge the exact same section, and one alleges a felony charge and one alleges a misdemeanor. State?
I looked this up. I believe, and I might be incorrect. I sort of like looked this up, noted the discrepancy, found some news articles on it, and trusted our system, which is normally pretty good at charging these documents. I believe the law was changed between these 2 incident dates to make this count a felony. I don't believe that's reflected on the statute website as of this time.
I'm pulling the statute website out and I was not finding that either.
But I believe I found news articles related to the law being changed in reference to the incident out of Minnesota with state representatives. And I sort of trusted our system, which indicated to me that when charging this incident, one that happened in December would be a misdemeanor and one that happened in January would be a felony. So I am looking specifically, and forgive me, it's been a long time since legal research and writing. But I'm looking at Wisconsin Assembly Bill 136, which is subtitled An Act to Amend Wisconsin Statute 946.70 sub 1 sub A, B, C, and D.
Wisconsin Assembly Bill, what number?
136. And is relating to classification of the crime of impersonating law enforcement officers, firefighters, and certain other emergency personnel and providing a penalty. Looks like that was enacted into law. One, 3, 6. Thank you. (2025) Wisconsin Act 55. It looks like it was signed by the governor December 10th of 2025, or at least approved by the governor.
Date of publication. Date of enactment. It looks like date of publication is December 10th, date of enactment is December 9th. And it does change the penalty between these two offenses, which then becomes a Class I felony, which is in fact what is charged in count 3. Having reviewed the criminal complaint, I will make a probable cause finding as to 1, 2, and 4, entering not guilty plea on Mr. Lampe's behalf. State's position on bail.
The state is requesting a signature bond. The state would request non-monetary conditions that the defendant have no contact with the individuals listed with the initials A, D, and K, L, M, and that is M as in Martin. And the state is requesting a ban from any place that AD or KLM reside or temporarily occupy.
Any Baju?
I have no objection to the signature bond nor the conditions.
I will then order no contact with AD and KLM, and I will order a signature bond for Mr. Lampe. Time limits as to the preliminary hearing.
The time limits.
Those are waived. A status conference shall be scheduled. We are adjourned.
So our numbers on the other side of that sheet.
Next up is Jason Summers. Right, so it's fine. What was it? Summers, thank you. Here's some paperwork for you. Summers.
But it's interesting that the two acts straddle the line
charged that case and I spent like an hour trying to figure out why it would made it a felony.
Oh, good catch.
Protocol 26 CF 196, State of Wisconsin versus Jason Summers. Appearances.
Cameron Davies for the state of Wisconsin.
Yes. Mr. Jason Summers appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Summers' complaint. I do waive its formal reading, reserve objections for a later court date. As of right now, the address on the complaint is correct. I have indicated to me that Mr. Summers is not eligible for the services of the Public Defender's Office. I see the bailiff giving the form with our number on it. Should his financial circumstances change, I would encourage him to reapply. And I would ask the court to enter a not guilty plea to count 2, the misdemeanor count in the complaint.
I have reviewed the criminal complaint. As to count 2, I would make a probable cause finding and enter a not guilty plea on his behalf. State's position on bail.
The state has no objection to a signature bond. The state would ask for conditions that the defendant have no contact with the individual listed as child victim 1. For the sake of expediency, that individual has the initials A.S. State would also ask that the defendant have no contact with any siblings of A.S. That the defendant have no contact with Michelle S. And that the defendant be banned from the 6,000 block of Tottenham Road.
Counsel.
So what I'm discussing with Mr. Summers is just the condition. I understand where it comes from. That is Mr. Summers' home. Obviously, this is his child. This is, the home that he stays. He has informed me that he understands it's a possibility that this court would require him to find a different address based on those conditions. He does not currently have an address to go to. He's told me he will certainly try to figure that out. I think based on the way the state is asking for the no contact order, I guess naturally I would ask for no acts or threats of violence if the court was comfortable doing that. If not, I would say, as long as there's not an address ban there, it would just at least leave open the possibility of him going back to the address if child 1 is not there. Certainly he can, he could request to keep the peace from the sheriff's department if he does want to retrieve things. But being that is his home address and that is where he has lived, I would ask the court to consider something along the lines of no acts or threats. Other than that, I have no objections.
There's a PSA report in this case. It does recommend a signature bond. It indicates no history for Mr. Summers. Given that, I will give him a signature bond. Reviewing the case, I do believe that there are no contact conditions are appropriate, so I'll order no contact with child victim 1, identified as AS or AS's siblings, no contact with Michelle S, and I will order a ban from the 6,000 block of Tottenham Drive. Time limits as to the preliminary hearing, counsel.
You're not waiving a privilege, you're just waiving time limits so that you can get a lawyer. That sound okay?
Sounds okay.
That's what I would do if I were.
Yeah, it's not our time to manage that either, so, well.
Okay, we'll waive the time limits, Your Honor.
Time limits are waived. A status conference shall be scheduled. We are adjourned. Good luck to you, sir.
Next up is Josiah PRUSAITIS. Yes.
Roll call 26 CM 201, State of Wisconsin versus Josiah PRUSAITIS. Appearances.
Cameron Davies for the state of Wisconsin.
Is it spelled correct on here? Okay, so if it's correct on here, then should be good. Okay. Mr. Josiah PRUSAITIS appears in person and in custody alongside alongside counsel Skylar Bojo from the Public Defender's Office, I have received a copy of the complaint, waive its formal reading, reserve objections for a later court date. The address on the complaint is correct, and I have indicated to me that Mr. PRUSAITIS is eligible for the services of the Public Defender's Office. In fact, he's been appointed attorney on another matter, so I believe he'll get the same attorney on this one. Being that all counts are misdemeanors, I would ask that the court enter not guilty pleas on his behalf.
I have reviewed the criminal complaint. Did you make a probable cause finding? I will enter not guilty pleas to Mr. PRUSAITIS's charges. State's position on bail.
State will request $500 cash bail. I'll ask for non-monetary conditions that the defendant have no contact with Natalie R. And that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. In terms of support for that cash bail request, I would note that this is the defendant's third open case across multiple counties. This case involves a violent offense, as does his underlying case here in Dane County. Both involve batteries. Additionally, he does have an open case out of Rock County right now. That is case 25 CF 1117. That involves multiple counts of fleeing and eluding an officer. Given that behavior while on bail and the repeated violent acts here in Dane County, the state does believe that some amount of cash bail is appropriate.
Counselor.
Thank you, Your Honor. If the court would be inclined to agree to it, I would just ask the court not to go above $500 cash. I'm looking at the PSA. It does make a cash bail recommendation. It also does say that he has no prior convictions of any kind. Looks like his failures to appear are older than 2 years. And I understand there is a step 2 analysis here, but these are misdemeanor cases. So I would agree to $500 cash, but I don't believe it should be any higher than that. Thank you.
Looking at the PSA report, it does recommend a cash bail. He does have prior failure to appear, is older than 2 years, and pending charges at the time of the offense. Given that these are violent offenses and Act 3 eligible, I do believe some cash bail is necessary to assure Mr. PRUSAITIS's appearance at future court dates and protect the public. I will order a $500 cash bond. No contact with Natalie R. That you not use or possess any controlled substances or drug paraphernalia without a valid prescription during the pendency of this action. We are adjourned in Mr. PRUSAITIS's case.
Next up is Ryan Johnson.
Okay, yeah, but you can't contact her. Okay.
Right, so.
Is it Johnson? Yeah, thank you. Here's our last name.
That'll be your last one. Yeah,
Okay.
we got one. Sure.
Yes. There's.
Yeah.
Thank you.
Court will call 26 CF 195, State of Wisconsin versus Ryan Johnson, appearances.
Cameron Davies for the state of Wisconsin.
Is that having difference? Okay, so I use that one. Gosh, now it's being. Should have just had her come to this. Come back. I'm just gonna represent you today. Also, there's a. Say. PSA on this one. So it's her chat to me. I was supposed to. Then where at? See, we both get for him. Pending cases requires. Mr. Ryan Johnson appears in person and in custody alongside counsel Skylar Bojo from the Public Defender's Office. I have received a copy of Mr. Johnson's complaint. I do waive its formal reading, reserve objections for a later court date. The address on the complaint is no longer correct. The correct address is 5102 Minders, which is MEINDERS Road in McFarland, Wisconsin, zip code 53558. And I have indicated to me that he is eligible for the services of the Public Defender's Office. So again, he has been assigned Eric Schluter on his other matters. I expect he will get the same attorney again. And I would ask the court to enter a not guilty plea to count 3, which is the misdemeanor count.
I have reviewed the criminal complaint. I do make a probable cause finding as to count 3 and enter a not guilty plea on Mr. Johnson's behalf. State's position on bail.
One moment. The state will be requesting $500 cash bail. I'll ask for non-monetary, the sole non-monetary condition that the defendant have no contact with Brittany P. In terms of support for that cash bail request, I'll note this is the defendant's 3rd open case here in Dane County. It is his 2nd involving Brittany P. He's violating a specific condition of bail. Moreover, when we take a look at the procedural history of his underlying cases, in the first case, 25 CF 2786, the defendant was given a $500 cash bond at his initial appearance back in December. On January 9th of this year, that was lowered to a signature bond. He then committed a new offense in his 2nd crime. He had his January 15th IA there. He was given a chance on another signature bond, despite the pretty immediate new criminal activity. And then within a couple of weeks of that is now violating a specific condition of bond and engaging in more criminal activity. So I think pretty clearly signature bonds are not working to deter both new criminal behavior as well as specific violations of bail. So I think that $500 needs to be put onto this case at this point.
Counselor.
Speaking with Mr. Johnson, I'm gonna ask that, so it appears that there's a misdemeanor crime here, which triggers the 2 new felony bail jumpings because of the open cases. I'm gonna ask the court to consider a cash bond of $200. Mr. Johnson, we've been kind of talking back and forth. He's not sure that he'd be able to post the 200, at least not right away. But I'm asking for that because understanding that there are open cases, the court is likely to impose some amount of cash. I don't know when he'd be able to come up with the 200. He said he might be able to at some point. He is a carpenter by trade. He was supposed to start a new job today at, what was it?
CTW flooring.
At CTW flooring. However,
I hope I can still get it.
he's hoping to still go back to that job. I'm not sure if he's going to be able to. He does have his kids in the area. He does have, he does rent a place in the area, and I don't have a PSA. I didn't hear anything about missed court dates. I think the basis for a cash bond was solely on the basis of the new charges. So being that it's not an Act 3 eligible offense, and being that he is making his court dates with the cases that he has now, I would ask the court to consider a minimal amount of cash bond of $200 in this case.
I would note Ryan Johnson does have a number of pending open cases. In the most recent one, 26 CF 195, there was a PSA report. I'm sorry, in the most recent one, 26 CF 122, there was a PSA report too. On January 15th, it gave him 5 out of 6 on a new criminal activity, 3 out of 6 on failure to appears, prior sentences to incarceration, prior felony convictions, prior misdemeanor convictions, and pending charges at the time of the offense. At the conclusion, it recommended modest cash bail. However, at that initial appearance, he was again given a signature bond. That was on January 15th. Here we are today with the new charges and the alleged violations. Given that PSA report recommended cash bail, he was given a signature bond. In this PSA, there is no report, but I'm sure those numbers increase. Given all of that and the state's argument, I do find persuasive. I do believe cash bail is necessary. I will set cash bail in the amount of $500. I will order no contact with Brittany P. Time limits as to the preliminary hearing counsel.
I'd ask that the time limits remain in place, Your Honor.
They shall not be waived. A preliminary hearing shall be timely scheduled. We are adjourned in Mr. Johnson's case.
Thanks. Next up is Tyson Christian for a forfeiture.
Get out of the way here.
Court will call 26-FO-165 Dane County versus Tyson Christian. Appearances.
Cameron Davies for the people of Dane County. The defendant appears in person in custody without counsel.
Mr. Christian, I have what some consider good news. The police department referred up criminal charges against you. The DA's office reviewed those reports and decided not to charge you criminally. Instead, they've charged you with 2 ordinance violations, one for county resisting and obstructing an officer and one for a county disorderly conduct. These are similar to parking tickets or traffic citations. They are municipal offenses, non-criminal. If this is the only thing holding you in custody, no matter what you plead to this case, you're going to be released. Sometimes it's a case that can get resolved today. What is the county's offer for resolution?
The county would resolve for court costs.
On both charges?
I'll do costs on one charge and dismiss the other. It can be the defendant's choice.
If you were to plead to one of these ordinance violations, the state would or county would dismiss the other, and I would assess court costs only, which would be $114.50. How do you wish to plead to these charges?
So I can plead one, Your Honor.
Yep, and the other one I dismissed.
I need to disorderly, one thing I'd like to add, I'm going back and forth, we probably had 28 days clean, I relapsed twice. And I almost never resist. I believe I was so incapacitated that I couldn't function. I probably didn't obey orders fast enough, that's usually what happens to me.
So you want to plead
So,
guilty
yes,
to the
that's
disorderly
fine.
conduct?
My voice should be, I know I'm guilty of disorderly.
All right, I'll find you guilty based upon your
The
guilty
one that
plea.
is questionable.
I'll dismiss the resisting and obstructing charge. I'll assess court cost of $114.50. You'll have some time to pay and it takes care of this violation. Good luck to you, sir.
Thank you, Your Honor. All right, that's right, this one. How's everyone's day?